The guidelines do certainly have an immediate impact on every industry and including the healthcare industry. It incorporates a more restrictive view of transactions. And for that reason, I think it's imperative that when parties are considering a transaction, that they give more advanced consideration to the antitrust implications of the transaction and start to develop just as early as possible the defense and the pro-competitive justifications for the transactions.
Hello and welcome. I'm your host, Dan Fahey. I'm an attorney in Epstein Becker Green's Healthcare and Life Sciences practice based out of our Chicago office. On December 18, 2023, after nearly 2 years of combined efforts from the Federal Trade Commission and the Antitrust Division of the U.S. Department of Justice, the agencies jointly issued much anticipated merger guidelines, which identify the procedures and enforcement practices used when evaluating potential mergers. The final version of the guidelines includes some notable changes made in response to public comments on the draft versions, which were previously released in July of 2023. Nonetheless, the main takeaways remain the same. How will the merger guidelines affect merger review and enforcement for the foreseeable future? What might these changes mean for hospitals, health systems, and other stakeholders in the healthcare industry? What do the merger guidelines changes mean in light of the broader government activity, including a recent FTC workshop on private equity in healthcare? Today, on Diagnosing Health Care, we are going to discuss some of the key changes in the finalized antitrust merger guidelines and what these guidelines mean for the agency's approach to enforcement.
Welcome to Diagnosing Health Care, a podcast featuring thought-provoking conversations about the latest legal, policy, and regulatory issues in healthcare and life sciences. Brought to you by the lawyers at Epstein Becker Green.
Joining our discussion today is Trish Wagner, a member of the firm based out of our Washington, D.C. office. Welcome, Trish.
Thank you, Dan. Happy to be here.
Also joining us today is John Steren, a member of our firm, also out of our D.C. office. Welcome, John.
Hi, Dan. Also, thanks for having this and happy to be here.
And last but not least, we welcome Jeremy Morris, a member of our firm based out of EBG's Columbus office. Welcome, Jeremy.
Thanks for having me, Dan.
Before we dive into kind of the key pieces of the finalized merger guidelines, I think it'd be helpful to set the stage and give the audience a sense as to how we got here. Trish, can you give us some background on the merger guidelines and how these finalized guidelines came to be?
Sure, Dan. As our listeners probably know, the agencies have always, or for a long time, have issued horizontal merger guidelines. And those are the guidelines that tell parties how the agencies will review transactions that come before them. The last time the horizontal merger guidelines were issued was in 2010, and the agencies also issued vertical merger guidelines in 2020. In 2021, both agencies, the FTC and DOJ, rescinded the vertical merger guidelines. And in January of 2022, the agencies jointly announced that they would be evaluating possible revisions to the 2010 horizontal merger guidelines, as well as those prior 2020 vertical merger guidelines. For that purpose, they scheduled a request for information in April of 2022, and they also conducted listening sessions. The FTC currently, often when it issues a proposed rule, will hold listening sessions for members of the antitrust community and the public to weigh in on what are issues that are important to them. The agencies drafted and released proposed revisions to the merger guidelines in July of 2023, and those were subject to a 60-day notice and comment period. They extended that notice and comment period by 30 days so they could get a few more comments. They had some additional workshops to discuss the proposed guidelines, and on December 18th, 2023, they published the final 2023 merger guidelines. And these guidelines incorporate both horizontal merger guidelines and vertical merger guidelines.
Great. Thank you, Trish, for that helpful background. It seems between what was proposed in July and then obviously the comment period, there are some key changes between what was finalized in the December finalized merger guidelines. John, what were some of the key changes or omissions that you noticed between what was included in the draft guidelines and what was released with the finalized guidelines?
As Trish mentioned, the agencies held a number of workshops and received just thousands of comments about the draft guidelines. And they did take these into consideration and made substantial changes to the final merger guidelines. And in fact, if you overlay the draft against the final, you'll see quite a bit of redlining. Now, a lot of that is just simply reorganization and some wordsmithing, but there were some significant changes. A few that caught my eye. First of all, the draft merger guidelines had 13 enumerated guidelines with separate headings. The finalized version cut that down to 11. The two that were removed, the first one was number 13, the last guideline from the draft merger guidelines. This was sort of the catch-all guideline that initially read, mergers should not otherwise substantially lessen competition or tend to create a monopoly. I'm not sure it was necessarily all that helpful when they put it in. As I said, it sort of was the catch-all guideline. And as far as trying to provide industry and practitioners guidance, which is what these are supposed to do, I'm not sure it was all that helpful. What is a bit odd is that while they removed the header of Guideline 13, they actually kept into the final the majority of the text that came after that header. So it's not quite clear to me what the thought process was in simply removing the header. The second guideline, which I think is actually more significant, which they did remove, was old guideline number 6. It originally read that vertical mergers should not create market structures that foreclose competition. Much of that language was shifted around to some of the other guidelines. For example, a lot of it was put under the new or sort of the revamped guideline number 5. But some of it was gutted, and most importantly, the presumption that the federal agencies had articulated in the draft merger guidelines was removed. That presumption read as follows. It said that foreclosure share is the share of the related market that is controlled by the merged firm such that it could foreclose rivals' access to the related product on competitive terms. If the foreclosure share is above 50%, that factor alone is sufficient basis to conclude that the effect of the merger may be to substantially lessen competition, subject to any rebuttal evidence. The elimination of that presumption, I think, is very significant for vertical transactions. Some of that reference to the 50% marker or demarcation does remain in the merger guidelines. They've actually pushed it down to footnote 30, but I think in doing so signified that its significance is less. And then finally, just sort of as a general tone of the merger guidelines, if you compare the headers of the guidelines from the draft to the final version, the language, the tone of the language, I think became more aggressive than it was under the draft. For example, all the references to should not take certain actions have been changed to can violate the law. So I think that was obviously meant to convey from the enforcer's perspective that these guidelines are reflecting what they think address transactions that actually might violate the law.
Looking specifically at some of these guidelines, it seems that they were structured around principles that are intended to be frameworks for how the agencies will assess a merger. And it seems like, as John said, some of the language was more aggressive, which might be some preview of how enforcement might take place. Jeremy, from your review, you had mentioned to me that guideline number 8, when a merger is part of a series of multiple acquisitions, the agencies may examine the whole series, caught your eye. Can you give us a summary of guideline 8 and kind of what were your key takeaways?
I think Guideline 8 was interesting from a couple perspectives. I think it was interesting from a substantive perspective and a practical perspective, and I'll talk a little bit about each of those. From a substantive perspective, and we've used the term here a couple times, aggressive, I think this might have been an announcement of a little more perhaps aggressive approach by the enforcement agencies. So in looking at Guideline 8, which references specifically multiple acquisitions, the agencies point out that when the Clayton Act was passed, and without getting too far into the weeds, the Clayton Act was intended to catch conduct that perhaps didn't rise to the level of violating the Sherman Act. So they pointed out that part of the purpose was to permit intervention in a cumulative process when the effect of an acquisition may be a significant reduction in the vigor of competition. I think from that perspective, they're kind of saying we always had the right to look into cumulative transactions and how that would impact overall competition. But I don't know that we've always seen that. I think what we've typically seen is, hey, let's look at this transaction, and did this transaction cause an issue in the relevant product market and geographic market? And sure, maybe there was some consideration of what had been going on around it. I think it was more around the line of, was there still competition left? This seems to be an announcement that the agencies now want to look at an acquiring party and say, is this part of some overall plan that you have to acquire competitors piece by piece by piece in a series of smaller transactions? And if so, they're announcing with this that perhaps they want to take action here, which I do think is a little bit of a departure from what they've previously done. I think this is also important from a practical standpoint, noting that we're on a podcast called Diagnosing Health Care for healthcare providers. And I think that's because healthcare providers see a lot of competition from smaller entities. And I think the most common place you probably see that is with physicians. A lot of physician practices aren't that large, that you see those transactions sometimes occur small transaction by small transaction by small transaction. And I think that's something that healthcare providers might want to look at as they consider these transactions as to whether or not this is the type of thing the government wants to pursue under Guideline 8 and pay attention to that.
Jeremy, we mentioned at the outset that the FTC recently held a workshop to address private equity in healthcare. Do you think the FTC is concerned about private equity acquisitions involving physician practices, and particularly when there are a series of acquisitions?
I think the antitrust enforcers are definitely interested in those types of transactions. And generally speaking, potentially private equity's involvement in healthcare. You see that interest in not only the workshop that was recently held about private equity, but the same day as the workshop, the FTC, the DOJ, and HHS also issued a joint request for information on consolidation in healthcare markets. And in announcing that RFI, the agencies did express some concern about private equity's involvement in healthcare, and they're just seeking to learn more information. Specific as to private equity acquisitions of physician practices, I do think they have concerns there about really understanding the ownership structure and being able to evaluate those and determine, okay, who does own these? Are these still competing practices, or are they working together? And that's something the FTC, DOJ are trying to consider as they move forward in their antitrust enforcement efforts.
Moving back into guidelines, John, you had looked closely at Guideline 1 and number 2. Can you give us kind of your insight as to what the impact of these guidelines will have, and any key takeaways that you found from reviewing them?
Guidelines 1 and 2, I think, are very significant for hospital clients and some of the larger healthcare clients that are considering transactions. And these definitely have an impact on what needs to be considered. What's reflected, particularly in Guideline number 1, is really the potential for antitrust intervention in what were previously classified as either moderately concentrated or unconcentrated markets. So whereas before, if you had a transaction in either of those types of markets, the antitrust analysis was relatively straightforward and didn't raise a whole lot of concerns. Now I think there is a need to be a little bit more proactive in analyzing the transaction. For example, under the prior merger guidelines, the ones that came out in 2010, when the concentration thresholds under the Herfindahl-Hirschman Index, the HHIs, required or had the presumption that came into place only for transactions that occurred in highly concentrated markets, that is, HHIs above 2,500, and resulting in a change in HHI above 200. What that sort of in a vacuum related to would have been a transaction, a 5-to-4 transaction, where you had 5 equal-sized parties. If 2 of them were merging, that would raise a presumption under the old guidelines. Under the new guidelines, where the concentration level thresholds have decreased down to 1,800, representing a highly concentrated market, and a change of 100, which equates to the presumption, you now have situations where a 7-to-6 hospital transaction, that is 7 hospitals in a market going down to 6 hospitals with all equal size market shares, that would now raise a presumption. So you're looking at markets, again, the impact is that transactions in those markets are more likely to raise a presumption than they did before. In addition, under the new guidelines, under guideline number 1, market shares above 30% and a change in the HHI above 100 now raise a presumption. This could create a presumption even in unconcentrated markets. So the impact certainly is significant. The reduction in the benchmarks for levels of concentration certainly is significant. When it comes to guideline number 2, this is the one that actually addresses head-to-head competition between transacting parties. In the hospital industry, that's always been an issue. We've always known that the enforcers have looked at head-to-head competition as an issue. They have used diversion ratios and paid attention to documents and the like that actually suggest significant competition between the transacting parties. But they've always put that in context of a larger market analysis. If you read guideline number 2 now, the reference and the clear implication is that the agencies might consider an elimination of direct competition between 2 close competitors in and of itself as unlawful, regardless of an analysis of the market. And just to crystallize that, the guideline says that although a change in market structure can also indicate a risk of competitive harm, an analysis of the existing competition between the merging firms can demonstrate that a merger threatens competitive harm independent of an analysis of market shares. So again, this suggests that the potential impact on hospital transactions is significant and needs to be looked at very carefully.
Trish, John talked somewhat about the head-to-head competition and how that has been analyzed in the past, but Guideline 6 pertains to mergers that can violate law when they entrench or extend a dominant position. You had looked into this guideline. What concerns or what are some of the key takeaways that you found that would be relevant for the stakeholders with respect to Guideline number 6?
So right off the bat, I will say that one of the things that bothers me a little bit about this guideline is the scope of it. It reads, right, the agencies can examine whether one of the merging firms already has a dominant position so that the merger may reinforce, thereby tending to create a monopoly. And they can also examine whether the merger may extend that dominant position to substantially lessen competition or tend to create a monopoly in another market. And when we think about horizontal mergers, critical to every analysis for a horizontal merger is the relevant market. And when we think about it in terms of this guideline, this is a guideline that seems to be trying to extend that market a little bit. And going back to Jeremy's example of physician practices, when you put those 2 guidelines together, picking up small physician practices one at a time, and then that we have the possibility that merger guideline 6 will look at that and say, not only are you picking up one at a time, and we're going to look at those in series, but now we're going to argue that perhaps you're entrenching monopoly power or extending monopoly power as you move across those geographic markets. And we know the FTC has had interest in this. We know that they have been looking at cross-market effects for a while, and this merger guideline seems to encompass that. It also, I might add, is a way to think about sneaking in some of the vertical merger review, because they do talk about things that they will look at in evaluating this guideline is things like raising barriers to entry by increasing costs associated with changing suppliers or depriving rivals of scale economies or network effects. And those you could easily see as being vertical impacts. For example, if a health plan is doing the physician acquisitions. The one piece of good news in Guideline 6 is the agencies did include the ability to rebut their presumption and demonstrate that the competitive benefits of the merger outweigh any anti-competitive harm. And again, competitive effects would be things like cost savings or quality improvements As always, those pro-competitive effects and those benefits you have to be able to demonstrate that they're real. So it's based on objective criteria, not subjective. And you always want to be able to show that those benefits are going to be passed on to consumers. The last part of that is you also have to be able to articulate why a merger is necessary to create those efficiencies, because the agencies will be looking to see if there would be another way to generate those same efficiencies, for example, through contracting or some other special arrangements.
Obviously, there's a lot to digest with all of these mergers. To wrap up, I'm going to ask each of you one final question regarding the finalized merger guidelines. Trish, I'll stick with you. I think it says in the introductory portion of the merger guidelines that they do not have the force of law, but how do you expect these guidelines may impact antitrust enforcement? Where will we see these play out in the years ahead?
As I think we discussed on our prior podcast, that's correct. The guidelines don't have the force of law. They are intended to demonstrate the agency's process in reviewing mergers, and they should reflect current law and how the agencies will interpret current law as they are evaluating mergers that come before them. I think one of the key points for merger guidelines is just that, right? They should be evaluating mergers based on current antitrust law. You don't want merger guidelines to be creating law, right? Because that's not the role of the agencies. Their role is to enforce the antitrust laws. Typically, courts have been very deferential to the merger guidelines, and we've seen that in a lot of case law. What remains to be seen, given the change in these current merger guidelines, whether the courts will show that same deference or whether the courts will have some concerns that the agencies are trying to push the envelope a little bit too much here and create new law rather than interpret current law.
Jeremy, turning to you, obviously you are a lawyer, so you're not a hospital leader, but if you were a hospital leader contemplating a transaction in 2024, based on your review of the merger guidelines, how might your approach or strategy change in light of what the agencies have released?
Following up a little bit on what Trish just said, I think it is important to keep in mind, again, these are not law. So I think you would still want to follow antitrust law as it exists when you're thinking about transactions. So I think we would want to, of course, keep a close look on the current state of the law. I think we would need to keep a close look on these merger guidelines and how they're being interpreted in the courts, because they were only issued on December 18th, and see how that might guide us as we move forward. But I don't know that it would cause a huge change at the moment, depending on what courts do. But the one thing I think I would suggest is perhaps start thinking about antitrust concerns a little bit earlier in the transaction. I don't want to speak for others, but I think the prior guidelines were pretty well settled. The antitrust laws have been around quite a while. So it's been my experience, sometimes folks will bring you into a transaction, say, hey, we wanted to get you on board. We'll let you know if anything comes up that you need to know, but otherwise, no news is good news on the antitrust front. I think I might suggest saying, hey, let's bring antitrust counsel in a little bit earlier, see if there's anything that we're doing that might cause us a question under the new guidelines. Perhaps even look at, hey, do we need an economist in this situation a little bit earlier to start looking for things, just to be ready in case the enforcement agencies do come calling, that we're ready to go and not playing a reactionary defense all the time. So I think that's the one change I would make, is perhaps the involvement of antitrust counsel a little earlier.
John, you get the last word. There have been a lot of developments under this current administration when it comes to antitrust policy. Where do these guidelines fit in the larger landscape? Do you think these are going to have an immediate impact, or what's your industry as a whole takeaway from what was included in these release guidelines?
Dan, I think this is a continuation of a very aggressive enforcement policy under the commissioners and the Department of Justice right now. Healthcare has, for a long time, had sort of a bullseye on its back when it came to antitrust review and enforcement. We've known that there is heightened scrutiny in some of the markets. These merger guidelines, I really think, just fit right in with what the current enforcers have been trying to do. So it's not a shift in what they're doing. I think it fits right in. It does seem to me and both Trish and Jeremy touched upon this point, the notion of creating new law. I think the enforcers have been trying very hard to bring cases that are novel, bring cases that have new theories, going away from sort of the more traditional consumer welfare standard. And I think these merger guidelines also play into that sort of paradigm. And the ultimate question is going to be whether or not the courts do adopt these guidelines as real persuasive authority, not law, but very persuasive in how they come out and reach their decisions. That's, I think, yet to be seen. The guidelines do certainly have an immediate impact on every industry and including the healthcare industry. It incorporates a more restrictive view of transactions. And for that reason, I think, and to Jeremy's point, I agree, I think it's imperative that when parties are considering a transaction, that they give more advanced consideration to the antitrust implications of the transaction and start to develop just as early as possible the defense and the pro-competitive justifications for the transactions. But I think that's what we're seeing, and I think that's what we'll continue to see under the current enforcers and with these new merger guidelines.
Thank you, John, and thank you, Jeremy and Trish, for taking the time to participate in today's discussion on some of the key changes in the finalized antitrust merger guidelines. And thank you to all of our listeners. I'm your host, Dan Fahey. If you've liked what you've heard today, please do not forget to subscribe. Diagnosing Healthcare is available wherever you get your podcasts.
Thank you for listening to Diagnosing Healthcare. For show notes on today's episode, additional episodes, and more insights on trending issues in healthcare and life sciences, please visit diagnosinghealthcare.com and be sure to subscribe on your preferred platform. This podcast is presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.